our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. I'm Andy Fowler, and I'm here with Sean St. Clair. Today, our topic is the constitutionality of the Corporate Transparency Act. We're going to get a little bit heady today and dive into the weeds on the Constitution. If you're new to the show, make sure to subscribe to our channel. You can find us on YouTube, Facebook, and X, formerly known as Twitter. You can find us at the handle at InRem Podcast. That is at InRem Podcast. You can also download an audio version of the podcast. Just go to Apple or Spotify, download it for free, leave us a review. We'd appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is basically an issue or something that came up in our Creative Finance Collective. And so the question is why is a performance promissory note required for a subject to wrap transaction in Arizona? And for Arizona, we always do performance notes secured by deeds of trust for our subject to transactions if it's going to be structured as a wrap as opposed to, say, like an agreement for sale or a lease with option to purchase. But if we're doing, a conveyance by warranty deed with a wrap, then in that case, we always do a performance note with a deed of trust. And we were on the collective with Scott Horn on Tuesday afternoons. And it seemed like for a number of weeks, Scott and I kept going back and forth and where I was like, no, you need a note. And Scott's like, no, you don't need a note. I'm like, well, what, you just, deeding it over? No, they have to perform. And, we secure the note or secure performance by a deed of trust and this and that. And finally, last week, it registered to me. And then I jumped on and said, hey, Scott, so we're talking the same thing, except the laws of each state may be different, whereby in Texas, you can just secure the buyer's performance, their agreement to pay the underlying mortgage with a deed of trust, a performance deed of trust, versus in Arizona, we can't do that. We have to have a note to go with it. And so I'll explain what I mean by that. So the law in Arizona, and it's mainly an interpretation of case law, basically says, hey, look, when you have a deed of trust, that is a lien against real estate. And basically what that is doing is securing a debt, or obligation. It doesn't always have to be a monetary debt, but it could be an obligation. It's securing a debt or an obligation, but it is not in and of itself the debt or obligation, nor is it in and of itself evidence of the debt or obligation. It is simply a lien instrument that secures an underlying debt or obligation. So unless you have an underlying debt or obligation, you do not have a lien interest in the property, even if you record a deed of trust. So the deed of trust in and of itself is simply a security instrument, and it is invalid and unenforceable if it doesn't have a underlying obligation or debt associated with it that it's securing. So example would be I borrow money and it's secured by a deed of trust, and I pay off that loan, but the lender doesn't release the deed of trust. That deed of trust isn't valid even if it still remains of record because the underlying debt and obligation has been paid off. If, say, my underlying debt or obligation, I owe money, but let's say the statute of limitations bars my performance under that debt or obligation, meaning I'm released from it because of the running of the statute of limitations. I haven't paid it off, but the statute of limitations is run. Well, even if the deed of trust remains of record, it's unenforceable because there's no longer an underlying debt or obligation. So to create your underlying debt or obligation, you primarily use a note. You could use other documents. There's other ways to do it, but the tried and true traditional typical way of creating that underlying debt and obligation is through a promissory note. So when we assist our clients with subject to transactions that we're, then using wrap, basically seller carryback wrap financing to secure the buyer's performance and the performances that they're going to pay the underlying mortgage, we in Arizona have to do it by way of a promissory note because that's what creates the underlying debt and obligation. And so unlike Texas, where apparently, according to Scott Horn, you can go and just record a performance deed of trust. And if the buyer doesn't perform, then they can foreclose. You can't do that in Arizona. You have to have that underlying debt or obligation, which is through a promissory note. And then you secure it by a deed of trust so that if the buyer does not perform, the seller has the ability to foreclose on the property.
All right. Thank you for the legal update, Sean. With that, let's go into a couple announcements. So every Tuesday at 2:00 p.m., we have the Creative Finance Collective. That is a group, a membership of lawyers, professionals in the space of creative finance. We get together, we discuss creative financing, and we take questions from the listeners. So if you've ever had a question about creative finance, thought about maybe getting into it, wanting to know what the pitfalls, risks are, rewards, all those kind of things, we talk amongst the lawyers from different states and different jurisdictions about creative finance, but we make ourselves captive to you, the listener, for questions. And we're on for as up to an hour or as long as we receive questions. So it's important for you to be there and ask away. We're there for you. So make sure to be there every Tuesday, 2:00 p.m. Arizona time. You can find it on YouTube, Facebook, and X. All right. So if you have any questions for us today as well, or for our guest, feel free to post those in the chat. We'll try to get to any questions that we have in the final 15 minutes of the episode. So today we're talking about the Corporate Transparency Act. You may be familiar with it. You may not be familiar with it. We've had a couple shows, one specific show dedicated to the Corporate Transparency Act itself, its implications, its requirements, its penalties, so on and so forth. It is a large federal act that governs the country at large and affects every individual thinking of starting into a business. We wanted to talk about, since having a show, the constitutionality of the Corporate Transparency Act, what that means for you, because there have been judges that have opined now and made rulings on the act, and there will be more. So with us to discuss that topic, we have with us Drew Jenkins from Georgia. Drew, how are you? Good to see you.
I'm doing well. Good to see you guys finally on the actual In-Rim podcast instead of just the collective.
Yeah, Drew is a regular participant on the collective, always has great insights for our guests or for our questioners who have questions on the collective. But we wanted to bring you on, Drew. You're an Alabama and Georgia lawyer, and we wanted to bring you on to talk about this specific topic. Before we get into it, for our listeners that might not be familiar with you, why don't you give them a little bit of background, what you do, and your law firm?
Okay, yeah, so I have Maple Bridge Law, which is the legal side of the firm, but we handle predominantly real estate transactions here in predominantly Georgia, but also still Alabama. It's where I'm from, right? So we handle a few files over there. These days, it's more and more commercial, but obviously got my start with the investors and the creative financing group, so I'm very well versed in the topics that come up on the collective. But that's really what we handle is we handle real estate and what I call real estate adjacent corporate work. So we used to handle formations basically until the CTA came. And I'm like, look, you know what? At this point, as you mentioned, it is a very broad act. It has some pretty serious penalties for violating it. And at this point, it's like, you know what? You can form your own entity, and then I can help you craft your operating agreement, company agreement, partnership agreement, bylaws, whatever kind of entity you have going on. So because of what we're going to talk about today, I have actually altered what the firm offers a little bit over here. But that's really kind of what we do is we enjoy handling it, and we handle a lot of international clients. A lot of our clients are international. Our office speaks at this point Spanish, Hindi, Gujarati, uh, Mandarin, yeah, no Cantonese, just Mandarin and Korean. So a lot of what's going on with this will really affect quite a number of our clients, and especially when dealing with international, they're not necessarily going to understand, why all of a sudden there's all these extra hoops to jump through. And so that's obviously part of the reason is the constitutionality of such what is essentially an enormous dragnet.
Yeah, so Drew, we're going to get into this. We're going to break down the or we're going to break down the Corporate Transparency Act. We're going to get into a constitutional analysis here. I know you've reviewed the case. You're familiar with the law, and like I said, we'll break all that down. But one of the things I thought might be important as we begin is a little bit of a civics discussion, because as we know, as lawyers going into a law school classroom and trying to dissect a case and its constitutionality, the facts, all that stuff can be difficult. But for just the average business owner who's trying to think, okay, what is going on here? What is the federal government trying to do? And how does this impact me? And what is this fight over? I think a little bit of civics is in order. And I guess I'll start with this. But one of the things that's unique about the United States, about a country that is governed by a constitution, as opposed to a monarchy, right, where you've got a king that might say whatever they want to say, and that is the law, right? Now, as Western nations have modernized over the centuries, you get less and less of kind of the divine right of kings, and now more of a democratic process. But our constitutional structure was unique in the sense that our federal government is a government of enumerated powers, meaning the federal government has only those powers that were specifically granted to them in the Constitution. And it seems to me that much of this case is really a fight over power, and whether the federal government either has the power or does not have the power. Do you think it can be broken down kind of from a civics perspective to be that simple?
Yes, and Sean and I were talking just a little minute ago before we went live, is about how, the court does offer ways for the government to basically salvage this legislation, right? Because again, sometimes it turns on exactly what this or the intent more so than exactly on what it's trying to do. So in this particular case, a massive act that requires everyone to basically a government entity, right? We're not registering with some random, you're registering specifically with FinCEN, the financial enforcement network, right? And this thing carries real penalties, both in monetary and in terms of imprisonment. And I think that's really something that the judge was pointing out is this is basically a police power, right? And so to your point, this is a question over powers is who has the power to intrude criminal penalties so deeply into the lives of citizens as it relates to, again, what the opinion points out is very clearly always has been and intended to be a state level power, because I think at base we all agree that or at least the Constitution was designed this way, like you said, is that the states are supposed to have more power than the federal governments, right? And it's very easy for us to move between states. And so whatever power is not explicitly granted to the feds is reserved to the states and the people, right? But in this case, it's kind of turned it upside down, where the feds are the ones that are really digging in far deeper than the states in an area that has, since the founding, even with the founding, has power to create entities, right? We'll use that because, you know, nowadays we have more than just corporations. The power to create entities is fundamentally a state level power. And the feds, while they are not mucking around with that, they are standing just outside the courthouse telling you, hey, I need to talk to you, right? You just formed something. You need to come over here and deal with me, or I'll throw you in jail or penalize you, what, $500 per day for up to $10,000? And that definitely seems on its face to be, you know, an overreach of a police power.
Well, Drew, just to kind of break it down a little bit, I mean, we're talking about a case here. So we're talking about the National Small Business United versus Yalen. And it's out of the Alabama District Court where you're licensed to practice. It looks like the federal government has appealed. What circuit court would they appeal to? What circuit court governs Alabama?
The 11th Circuit Court of Appeals here in Atlanta.
Okay, so it's going to go up to the
You'll go
11th Circuit in Atlanta, and then
Atlanta.
So it'll go to the 11th Circuit in Atlanta, and then presumably somebody's going to, obviously somebody's going to win, somebody's going to lose. And then it goes, I guess, from there to the U.S. Supreme Court. Is that accurate?
Yes, that would be the path, though. I mean, obviously this case forum shopped, right? Let's not sugarcoat it, right? They brought it in the Northern District of Alabama for a reason, even though, as they point out, the plaintiff has, I think they said 65,000 members spread across like all the states. They picked this jurisdiction for this particular outcome. Obviously, the 11th Circuit, being conservative, at least with relation to, you know, federal power and states' rights, is going to have a sympathetic ear, and then it's going to go to the U.S. Supreme Court. So I have a feeling that we're going to get it's going to be upheld at the circuit level, and then, you know, the gloves are going to come off when it hits the U.S. Supreme Court. And that's an interesting thing that you pointed out, is even though it has been found unconstitutional, the case is limited to the plaintiffs that brought the case. So unfortunately for the rest of us that are not part of that plaintiff group, and the feds made sure to point it out on their website, this is still enforceable against all the rest of you. So line up, and literally.
Is it too late to join the National Small Business United?
I don't know. I have a feeling that would be a new lawsuit. Would apply, you know, only as to who remembers at that point in time, or on a go forward basis. Great question, though.
So let's kind of jump into, you know, this case out of Alabama. I know there's other cases that are also pending at different district courts throughout the country and United States district courts. And but in particular, looking at the Alabama decision here, really, how would you just describe the main issue that this court was having to decide?
I think I brought it up. Fundamentally, this operates as a police power, right? I mean, you got the financial criminal enforcement network, you have monetary and, you know, criminal penalties that are attached to this. And so the question is, on what does the federal government hang their hat to make this law constitutional, this exercise of what clearly seems to be a police power of some sort? And the answer is, well, not much. So the government had a scattershot approach, right? They brought up, oh, well, hey, this is, this is foreign affairs, terrorists, give us the power. Well, I'm glad to know that literally, perhaps your mother or father who creates a little LLC, for something they're doing for like a bake sale or something. I'm glad to see that, they're not terrorists. The other one they tried to hang their hat on, which is obviously the big one that we study in law school, is laws. It's extremely broad. And so they hung their hat and said, obviously, this affects interstate commerce. And the court said, well, that's great, but then why don't they ever talk about commerce in, the provisions of the act? If this is what you're hanging your hat on, we need to have a discussion about it. You can't just say anything that touches interstate commerce is interstate commerce, because then you blow up the entire separation of powers. Congress can regulate anything they want if you can do a but-for analysis to get to, interstate commerce. And then the last one, which is always the last ditch effort of the government, it's a tax. Right, it's under the taxing authority. We have very broad sway. And once again, the judge said, well, if this were intended to be a tax, it would have been really nice of, Congress and the law to mention that this was meant to be a tax. It also looks a little odd that, there's, it's applied equally across all measures. There's no graduating schedules. And of course, it raises revenue. But then again, anytime the government collects money is raising revenue, but the mere collection of funds does not mean that it is in fact an exercise of the taxing power. Again, that's why, we were talking earlier, the court kind of gave Congress ways to try and salvage this act. They just need to go in and try and more narrowly tailor what they're doing. And I think the very beginning of the opinion really lays it out. And I like the first one, but he actually goes with the opposite. Is the Scalia once remarked that federal judges should have a rubber stamp that says stupid but constitutional, right? So Congress can do things that we don't necessarily agree with, but it's constitutional. But again, the judge actually reverses it and says sometimes Congress enacts laws. So the judge starts out very pathetic to, look, we all understand that money laundering is an issue. We understand that the illicit movement of funds is a problem. But at the end of the day, even though your intent here is very clear and noble, this is just way too broad. You're just affecting too many people that have no direct, it's the thing in law school, there's actual causation, which is what the feds tried to argue with the but for, and then there's legal causation, right? In this case, you obviously have but for causation, but legally you're just too attenuated, right? The behavior that you're attempting to watch is just too far removed from the behavior that you are attempting to regulate.
One of the things that I thought was interesting was the judge's concern with the fact that entities are created not by federal law, but by state law. Can you go into, why the judge seemed, to think that, it's problematic that the federal government is regulating every entity, every LLC, every corporation that is created, by state law as opposed to federal law?
Yes, because it's been very well settled. And in fact, this was part of what the founders were discussing is some laws, some powers belong to the federal government. Everything else is reserved to the states. The states at the time of the founding, obviously there was no federal government, so they formed corporations because that was really the only thing you had, right? You had general partnerships, which don't require formation, and you had corporations, which required basically a government seal of approval. And so the states were the entities that gave the seal of approval. There were discussions about saying, hey, it should be the federal government. And outside of some varying categories, right, such as Amtrak and the TVA, there are no federal corporations or federally incorporated entities. It has always been handled at the state level. It's a power that very clearly remains with the states. And this particular law is now, the word is not commandeer, it's not preempt, but it is mucking about in the actual operations of, the state formation. Like I was saying, today with the internet, things look a little different. But back in the day, in order to form a corporation, at least when I was young, like you had to go to the courthouse, right? Like you had to go make like 4 copies of your corporation, incorporation paperwork. You had to go deliver an original plus 3 copies and bring money and all this stuff. So if we were still in the pre-digital age, you would go do that. And like I was saying, the moment you step out the courthouse doors, there would be a federal like officer, not an employee, a federal officer waiting for you to say, hey, I understand you just formed an entity, right? I need you to come over here and talk to me. And you say, no, I don't want to. And then they say, no, you must come talk to me, right? Because if you don't, I can throw you in jail for up to 2 years or $500 per day. And I mean, that sounds a lot more sinister, right? And I'm doing it on purpose, but it illustrates the point is now the federal government is literally looking over the shoulder of everyone who is engaging in an extremely common, even for non-economic purposes, a very clear state power, which is forming entities. And I mean, that clearly seems to be a problem. And it's not that the entity is being held responsible. The judge also takes a moment to point out that these penalties don't go against the entity. These penalties go against the people themselves. So again, to the point is you would have a federal officer, right, with criminal enforcement power standing there calling everyone over that walks out of, the probate office or the, company Secretary of State's office, however your jurisdiction forms entities. And viewed that way, that does seem kind of like a hard pill to swallow.
Yeah, another position that the government takes in advocating for its power to regulate this activity is their foreign affairs power. So, admittedly, I think everybody would agree, the federal government in its most basic function is the primary actor for foreign relations, right? They conduct wars, they defend us, they negotiate with other countries, treaties, so on and so forth. So their power with regard to foreign companies, foreign individuals, whatever the case may be, is really plenary, right? I mean, it's really pretty extensive. But that really bumps up against here their power domestically. And they seem to contend that they have the right to regulate this conduct because there's some foreign implications through money laundering and so on and so forth, and therefore they should be able to track filers under the filers that are forming corporations. This judge wasn't really sympathetic to that because he couldn't see really the nexus to that. What were your thoughts on that and the government's argument as to its foreign relation powers?
Well, that's going to be the theme that we see over and over again is, well, maybe a subclass of what we are attempting to regulate might be engaging in these behaviors that we all agree. The first thing that comes to my mind is the whole, governments think of the children, right? We should always enact some new regulation. Think of the children that might occur with some subset of whatever it is we're doing. And it's the same thing here is, oh, well, there might be terrorists involved. That's why I use the example of, Sean's family member forming the LLC. If you're concerned about, foreign affairs, why is this not tailored to, non-US persons forming or operating or being beneficial owners of entities, right? I mean, you can more narrowly tailor this law to try and weed out the conduct that you're looking for. And they didn't. They just filed this massive dragnet on everyone. And again, I think the court took pains to point out at the very beginning, this is not just a government database. This is a government criminal database. This is a search and seizure kind of context here, right? That's why they kept saying the first, fourth, and fifth, amendments are being implicated because, this isn't, oh, hey, I signed up for Social Security. Right, you got my info. This is going in a criminal database to be used for criminal purposes against every potential criminal, which is literally everyone who forms, everyone who owns, or everyone who has decision-making ability, entity that's filed at the SOS level that's not otherwise exempt.
I almost think too that it's forcing the citizenry to create a database that is easier to source than what is currently available. And what I mean by that is they're basically wanting the citizenry to do their jobs or make it easier. And so, for example, here in Arizona, no money launderer is likely to form an Arizona LLC because we're not an anonymity state. And so, the law already provides in Arizona that if you own more than, say 10% of an Arizona LLC, you have to put your name on the paperwork and your name's going to be published. And versus say Wyoming or Delaware, it's a little bit different. Some other states, it's going to be different. If you are a manager of the LLC, the state law requires that you put it on there. But so why would Arizona LLCs who have fully disclosed and made it public record who their members and managers are have to then report this information to FinCEN? Unless the feds just say, hey, make it easier for us to source our data, right? We don't want to have to go to 50 state Secretary of State's websites or offices or the Arizona Corporation Commission and get this information because it makes our life more difficult. Do you see that as being something behind the law as well? Because otherwise there's no purpose in making Arizona LLCs and their owners report this information.
I think part of it is we'd have to remember that Congress are not experts in everything they regulate. In fact, often I would say they're not experts at hardly anything that they regulate, which is why they write these very broad laws and rely on the executive branch through the agencies to actually flesh them out. I think that if you asked, and I would even say that even some of your own representatives are probably not aware of the Arizona disclosure requirement. So I would say it's more born of ignorance than it is some of desire here. They be wholly unaware that that's even an option. There was a section later in the provision that said, look, the commandeering provisions don't really apply because we're not trying to force the state. And so to your point is, if the feds reached out to the Secretary of State and demanded all of this publicly available data, in a format that required it to be, I think you would have a pretty, strong argument that, hey, we're the states. If you want our data, it's publicly available. It's going to come in the form that we provide it. It's yours. So I'm not sure that additionally, or even with knowledge of, Arizona's law, it's just we feel that for reasons we need to collect all of this data, and the best source of collecting it is going to be from each individual who files and each individual who owns and each individual who has decision-making authority in every. I have a feeling that was probably more the thought process behind it, but you also raise a good point that was raised in most of this data in different ways. Data is available to the federal government because most entities that are engaging in the bank accounts already, they are already tracking beneficial ownership, and they're already tracking, operating authority within companies, and they're already turning this data over to FinCEN, right, under the Bank Secrecy Act. And the judge, well, what is the additional benefit? I mean, the burden is clearly very high, right? And the penalties are clearly very high. So I'm not seeing a benefit here, and I need a power to hang my hat on. And we've already covered the foreign affairs. Andy's right. You have plenary power in foreign affairs, but I'm just not seeing what that has to do with Joe Blow forming an LLC to hold a piece of property he bought in, Louisiana for the next 20 years and then sell it, right? We're not, that nexus as far as foreign affairs seems to be non-existent. And then we move to the next area of discussion.
Well, and I think that's just it, which is they basically like you said before, took a shotgun approach. They made no attempt to really analyze the legal landscape for these formations and to look and say, okay, what do we really need? And let's narrowly tailor an act to obtain it. And so to your point, here in Arizona, when we form LLCs, it's like $85 and you can form an LLC and you form it and you forget it. Like I have LLCs that I formed years ago that I don't operate in, but maybe I wanted to reserve the name or something like that maybe I'll activate and get an EIN for, but it's there. Well, back in the day, I could do that and FinCEN accepted out old entities that aren't active. But now if I wanted to do that, form an LLC just to have it because I wanted to reserve the name, I wanted to be able to use it at some, future time. And in Arizona, I can do that for $85. I get an LLC forever. And, it's maybe not going to do any business, but all of a sudden now the feds are like, oh no, you got to report every time you change the address, every time, the minute you form it. I'm like, I'm not even operating. Like I'm not engaging in commerce. I'm not engaging in foreign affairs. Literally, I just want a name to protect by forming this LLC. And now I have to go through this burdensome thing and give you all my personal financial information. To me, that just seems like way overreach.
Yeah, and that was kind of the whole point is, this is almost, I would use the term maximally burdensome, right? And again, the judge points out that it's for a noble cause, right? It's for a good cause, but there has to be, and I think that's why, because you point out, judges aren't supposed to like help Congress salvage laws, right? If it doesn't work, it doesn't work, just cut it and send it back. But this judge actually took the time under the commerce and the taxing clause. I mean, Andy's right. When it came to foreign affairs, they're like, where, right? Where? But when it came to both commerce and taxing, they're like, look, right? If you just hone this in, right? I don't even think narrowly tailored, but if you just give me something, because right now I've got nothing. If you just give me something to put my hat on to say this is constitutional, right? We can probably make this thing constitutional, but from that particular judge's analysis, it's just not there. It's too attenuated. There's just not enough nexus to get over that hump to make such a burdensome regime constitutional.
Yeah, and I thought it was to that overall point, especially in the Commerce Clause. You would think, being that this is this regulation has to do with businesses, you would think, okay, commerce, interstate commerce. The courts have loved to try to find a connection in the past on how this could be regulated in that way. Okay, that would seem to make sense. But one of the things that the judge makes a point of is facially, they don't even say this is regulating commerce. And facially, or on the bill's face, it just regulates an act having really nothing to do with commerce. And oftentimes those bills will have a purpose statement or something to the effect of, we are regulating, or this is the type of commerce we're trying to regulate. This is really just, I think the court points out, an intrastate act that happens within the state. Really, as far as we can tell, having nothing to do necessarily with commerce one way or the other. And but to the court's point, they didn't even seem to think through the constitutionality of the act as they were putting together the law, something that you would have thought that they could have done on the front end, making their job a little bit easier. But I think it's more of an example of what Sean was saying earlier, kind of a shotgun approach.
And I mean, that's the bulk of the opinion is, the various commerce clause analyses, right? Because you're right, generally these days, if you read the Federalist Papers and the Federalist debates, right, everyone's worried about the necessary and proper clause, which funnily enough does get brought up in this context, right? But ultimately what the government has found is its most useful, power is the Commerce Clause. And yeah, there's no mention of commerce. And I think you're right. The analysis on this was not at the time it was passed is, oh, this is a commerce power. I think given the way that the CTA was put together, this is a police power. right? Fundamentally, this is illicit activities, monitoring all of that. So, and of course, federal police power is far more constrained than the Commerce Clause. And I mean, to me, that just seems to be the reason for the law is one that falls under, federal enforcement actions, not, the regulation of interstate and international commerce. So they didn't see a reason to mention it because that is not the purpose of this. They're now on the back end trying to find a way to salvage something that, as it facially appears, is not salvageable under, the intent of the act, right? So yeah, you're exactly right on that. So the Commerce Clause, for people that may not realize, is this is the fund one the federal government uses to expand the scope of federal power. So anything, almost anything that has to do with interstate commerce, right? Be it the actions themselves or the instrumentalities of commerce, drivers, the people that actually move things. This is why wire fraud is federal, right? Because wires are handled through the FedWire system, which is itself the 12-member bank spread across the United States. Every time you send a wire, you are implicating interstate commerce, even if it's going from one local bank to another local bank. You've used an interstate system to do so, and you've implicated interstate commerce. So it's an extremely broad power. And it's the one that, as Andy said, generally is used to get things passed. In this case, just forming an entity just in and of itself doesn't actually have anything to do with interstate anything. It's not like the judge used the example growing the marijuana, right? Is by you under California law growing for personal consumption. Of course, this is just Wickard v. Filburn all over again, right? The fact that you're engaging in an activity that is part of interstate commerce is itself interstate commerce. Forming an entity in and of itself has nothing to do with interstate commerce. You can form a company and, like to Sean's point, you can form a company and never use it, right? You have nothing to do with interstate commerce. But again, if you decide you want to grow a substance that's legal in California, the mere fact that you have grown it now means you're not going to consume some that was grown elsewhere and does implicate. So you always have to keep in mind the Commerce Clause is extremely expansive in many respects. And even with such a broad analysis available to the court, the judge still says just forming an entity in and of itself, which is what triggers this, this disclosure requirement, you can't read it that broad.
Go ahead, Sean. I know you had a question.
So let's jump to the taxing power. So the federal government has, argued, well, we have the power to tax. And frankly, I think ever since the Supreme Court decision on Obamacare.
Yeah, we've all had PTSD since then on the tax.
Yeah. And of course, now the government, like anytime they can, they're arguing our power to tax, and so they may have just thrown it in because that's kind of their MO, I think nowadays, like, hey, power to tax. Talk to us about the argument that the government made on the taxing power and then the court's ultimate decision there.
That I heard all of that. Can you all hear me?
Yeah.
Yeah, we can hear you.
Okay. So yeah, PTA Affordable Care Act, the way that, that was salvaged is the Affordable Care Act. The decision to not engage in interstate commerce is itself a decision to engage in interstate commerce, right, under Justice Roberts. However, we don't need to go that route because this is clearly a tax, and it was a very unique analysis, right? He needed to reach a result, and so he made some law to pull it off. In this case, the government, I guess, now thinks that this is their new Commerce Clause. This is their new go-to to get things done. Is it raises revenue? It, will increase collections, and therefore it's a tax. And that's pretty says, well, if it's a tax, just because you raise revenue doesn't make it lawful under that the government does raises revenue without them having anything to do with the taxing power. I mean, I don't think fishing licenses you need to regulate under the taxing power, right? You have plenty of other powers that you can reach to for things of that nature, and federal hunting licenses. So just because it makes some money for the government doesn't make it a taxing power. Just because it makes the enforcement of collecting of funds does not in and of itself make it a taxing power. However, the judge did point out, if it was intended taxing power, they could have given us some facial reasoning as to how this is a taxing power, but he gave a caveat to that. It is intended to be an actual taxing power. It's not right, it's just a flat monetary penalty that's applied across all persons. And the difference is the Affordable Care Act obviously is partially baked into how much income you make. So I mean, it looks like a tax with a graduated rate schedule. The Corporate Transparency Act has none of the hallmarks of a tax itself, although the judge acknowledges it certainly will potentially assist in the collection of revenues. But they don't have to even get to that because the banks are already supplying the information anyway. Right. So if you're worried about the funds and the money these things are dealing in, these entities, the banks have already collected beneficial interest information, and the banks are already holding and transmitting the funds between entities. So if you're worried about your taxing and spending, just go talk to the banks, which you have already regulated lawfully, right, to provide you with the information that you're now claiming you need to seek additional the individuals who may not actually be involved in any sort of business at all. And so that one fell pretty short, pretty fast. The bulk of the analysis was the very broad Commerce Clause, and is there any way that the judge could salvage it? And at the end, the judge said, no. Foreign affairs, too far apart. Commerce Clause, various analyses underneath it, no. Taxing power, well, if you want it to be a tax, it's not designed like a tax. And again, it would have been nice to get some sort of facial recognition that, oh yeah, we're intending this to assist with the collection of revenue, and we find this to be a valid, but again, all of which is from the text of the act.
Well, and to those that would approach this, well, what's the big deal? The government needs to have the ability to see data in order to protect us from bad foreign actors, whatever the justification might be. One, we do think it's a big deal. As lawyers who form companies, this is a pretty massive expansion of federal power into the areas of everybody's lives. But what's interesting here is, we haven't really talked a ton about the slippery slope. But one can imagine, and the court addresses this specifically as it's talking about the taxing power, because one of the arguments that the government makes is, well, this is appropriate under the taxing power because we collect the data and then we're going to share it with the IRS enforcement agencies. It helps them, and therefore it's a proper use of the taxing power. And the court specifically notes, if that's the justification for federal power, then literally the government could pass any law that collects data, and so long as they're sharing that with the IRS enforcement agencies, well, now we have that within our purview to control. I'm not sure what area of life couldn't be touched at that point, and the court seemed to agree there. But that's what I mean about the slippery slope and the dangers in acquiescing to or following some of the reasoning that the government provides in support of its arguments.
Well, I mean, and that really was, going back to it, is the government was finding some way to justify this. And, the first argument was, think of the children, right, under the foreign affairs, right? The second one was, well, these companies generally will engage in business, therefore I can regulate it. And the court shot back, and again, with the whole concept of class and subclass, just because some subclass of people might engage in the activity that you're worried about does not give the government carte blanche ability to regulate the entirety of the class, especially one that in and of itself does not implicate interstate commerce, just the formation itself. And then directly to your point with the taxing power is, well, just you might catch some bad people, right, because of this does not give, and of course that's where you made the point the most direct, is doesn't give you the power to regulate it, because to your point is, if the government can choose any of these reasons, which are good intentions for doing something, then there is literally no limit to what the federal government can compel you to do, which is obviously antithetical to the entire concept of having a constitution. If I can just say, well, I don't think it was under the taxing power. It was back under the foreign affairs. The judge made another really good point, is the government was, well, we passed this law to come into compliance with international anti-money laundering laws. And the judge was like, as good a policy as that may be, right, to get alignment with, international standards, the Constitution does not permit you to exceed the boundaries of the Constitution just to follow, international standards. Because, Andy, directly to your point under the taxing power, if that were the standard to determine whether a law should be, upheld or not, then there is no limitation. Because if international standards decided something and you adopted it, and that's our litmus test, well, then what's the point of the Constitution, right? If all we have to do is follow international law. And he raised the same point again with the taxing power as well. As well-intentioned as this might be, if the ability to assist with the collection of taxes is the litmus test for the validity of a law, where exactly does the federal government end? And so over and over again. And that's why I think if this were brought in another jurisdiction, another judge elsewhere could have very easily hung their hat on interstate commerce, right? They would have found some way to get that one through. The taxing power, I agree. I think that came from the Affordable Care Act. I think that's going to be the new way to get it done. The foreign affairs, yeah, that would be amazing if that makes it across anywhere.
So if you were a betting man, obviously you said, oh, another judge could have gone a different way. I agree. So we're going to the 11th Circuit and then probably up to the U.S. Supreme Court. If you were a betting man, what's the result?
I think the 11th will uphold what the district court. I think he will uphold it. The Supreme Court. Oh, that's a good one. I mean, Roberts is the one that finessed his way into upholding the Affordable Care Act, and Roberts is still the one up there. We've got a different lineup this time. I don't think I'd be willing to wager money at the U.S. Supreme Court, but I could put down a little bit for the 11th Circuit on the as being an overreach and lacking sufficient basis. But again, even this judge in probably as friendly a jurisdiction as you're going to find, maybe outside of Texas or something, he basically gave them ways to validate it, just narrowly tailor it a little bit more, and or give us spatial reasoning under Commerce Clause, or give us some discussion under the taxing power, right? Give us the nexus we need, and he would have probably could have reached a different conclusion.
Drew, I'm curious, this might be a cynical way of looking at this. And we kind of discussed this a little bit before as to whether legislators are just inept and aren't thinking about the constitutionality, or the other option is, look, the Constitution is incredibly difficult to amend. It happens very rarely, hasn't happened in decades. It requires a lot to amend the Constitution. Creating bad law, giving the courts an opportunity to analyze it within the Constitution, is one way to write new law, right? That's one way to attempt to do this. So, the cynic in me is, well, they passed this knowing a lot of it was unconstitutional, maybe all of it, and let's just see what survives the courts. I mean, you think there's anything to that, or do you think they just, I don't think they rushed this bill. This bill was in the process for a long time, having trouble getting it passed. Curious your thoughts on that. My thoughts are they see what sticks and what won't.
That is a cynical view, and I think that is being too kind to them.
Oh.
And I say that because I used to be a law clerk when I was young on the U.S. Senate, on the Administrative Oversights and the Court Subcommittee of the Committee on the Judiciary for the U.S. Senate. And I remember I was there during the DREAM Act hearings, And I was there when, Obama was going to, mint that like $1 trillion coin, right? And the reality is there is so much legislation and there are so many bills and they are so lengthy that the majority of Congress people, obviously with election cycles for the House that occur every 2 years, and of course, the Senate's every 6, you're 100 and something. I'll give you a great example. So this was for the DREAM Act, right? The bill itself, spanned hundreds of pages. I had to read the thing and then I had to summarize it. And of course, I know what my senator is looking for, right? I know what he cares about. And I summarized it down to a paragraph. And then I gave it to my boss, who was the, legislative committee person. And she summarized it down to a single sentence about whether or not, we, of course, the senator is very, very busy. And that is, unless it's their pet issue, that's really how the bulk of legislation gets passed. I had an aide that came in because we were in a subcommittee, in the base Dirksen, right? We like underground literally. And he came in and said, you guys are lucky with us because at least on the committees, you actually deal with policy. He said up on the actual like committee and everything, it's all politics all the time. So I don't think that they did it to have the courts figure out what's going on, right? Knowing that it's constitutional, unconstitutional. I don't think that the bulk of them are even fully cognizant of what is in it. They just know that their side supports it, and that the committee staffers, who are the ones who have spent all the time writing and building and analyzing it, have looked at it through the lens of their, employer, their congressperson, and they give a thumbs up or a thumbs down. I think having been in it for half a summer, I think that is the unfortunate truth that I experienced there. I don't think they pass it going, oh, we'll let the court sort it out. I'm not even sure they know what. I'm not sure. Unless it's their pet issue, they don't even know what's in it.
Interesting.
It's a bit
well.
sad,
This has been a really good.
What I experienced.
Yeah. It is sobering. Well, we appreciate you taking the time to go through this. Let's do this again after the 11th Circuit rules. We can make new predictions as it approaches the Supreme Court. While we have you, tell our listeners where they can find and connect with you, Drew.
Well, obviously, you can find maplebridgelaw.com or jenkinstitle.com. They're both going to take you to the same place. Again, we do predominantly real estate and corporate adjacent work. And so that's where you guys can find me. Another place you can find me is a little bit later today at the Collective, back with these guys here. So I look forward to joining y'all again to talk about creative finance.
All right. Thank you, Drew. We'll see you at the Collective, and we'll see you next time after the 11th Circuit rules. Have a good one.
Thanks, Drew.
All right. With that, everybody, that is our episode for the day. You heard Drew. Make sure to join us at 2 p.m. for the Collective. We'll be live taking questions. We'll see you all next week.
Have a good day, everyone.